Hello and welcome to the Rogers Brief for November 20th, 2022. I'm Adam Rogers. Thank you for watching and thank you for listening. I'm going to, a couple of programming notes, I guess, to start with. First of all, if you're following along with the Mass Casualty Commission, and probably some of my viewers and listeners have been, you might know that there's been some news this week. I'm going to cover some of it, the Onslow Belmont situation, fire hall situation. That shooting was the subject of some news, but there's also the closing submissions, the written submissions from all of the parties, all the participants have now been posted to the Mass Casualty Commission website. I've started scanning through them. I'm going to do a special video just on those closing submissions because it shows how the different participants view the evidence that have been brought before the commissioners, and just sort of shows their positioning. And of course, some of this is going to have some influence on the final outcome and the final report from the commissioner. So I'm going to cover some of those in a special standalone Mass Casualty Commission episode, probably middle of the week, hopefully a little earlier than that, but we'll see. And the second thing, thanks for everybody who's purchased and read some of Deficits of Trust, which is my final report on the Mass Casualty Commission and the events of the mass casualty in the ebook. I've covered the events themselves, what we know, and constructed, I think, a pretty reliable narrative and timeline of the events as they unfolded over the 13 hours. Talked about Gabriel Wortman, and then talked about the Mass Casualty Commission itself. So I've covered that in the ebook. The first 15%, which is a little more than the introduction in some of the early pages of the Gabriel Wortman analysis, that's available as sort of a free preview of the book. But what I'm going to do is I'm going to do sort of an audio book version of that, which really is going to involve me reading the first bit, the introduction. I'll do that as a YouTube video. I'll post it as a podcast. So if people are interested in that, and there seems to be some good feedback from it, then perhaps I'll do the entire book as an audio book. So people like to consume their media in different ways. Some people like to read. Some people like to watch the videos. Some people like to listen to podcasts if they're in their car, if they're out for a run or doing things around the home. So I'm going to try to be accommodating to all of those different ways to consume the content, and we'll see. We'll see if that is something that is enticing to people. Then I'll continue on. So this week has been an interesting week. I've been doing some work with Friends United. Rolf Baumann, who's a real estate developer, originally from Germany, immigrated here 35 or so years ago, but he's a major supporter of First Nations artists, Indigenous art, and has an international conference center just outside of Port Hawkesbury. Many people don't know about it, but it's gaining in prominence. Anyway, over this last week and then over the next few days, we've been doing the second annual reconciliation talks, is what they're called. And these are interviews, discussions, conversations hosted by Nancy Regan, who many people would remember, of course, from her days at Live at 5, who's just a fantastic leader of discussions and interviewer. And so she's been speaking with some of the artists, including Loretta Gould, who people will recognize from the art at the departure lounge or the departure area at the Halifax International Airport. There's like a 400-foot by 8-foot display area of her art there. And so artists, chiefs, political leaders, including former premiers, Stephen McNeil, Ian Rankin, and Rodney MacDonald, other local leaders, wardens and such. So it's a really fascinating series of interviews, but it's been a busy time as well. I've been participating in the interviews as well. One in particular, the reason I brought it up is one in particular involves a discussion about Donald Marshall Jr. and his impact in the sort of legal community, but also on the wider community. And so it's Nancy Regan, myself, and Hereditary Chief Stephen Augustine. And Chief Augustine is the head of the Unama'ki College at Cape Breton University. Hereditary Chief, which means he's sort of a spiritual advisor to the elected band chiefs throughout Mi'kma'ki, and So a really fascinating guy, and he knew Donald Marshall personally, and so some interesting stuff there. I say that, so those that aren't familiar with Donald Marshall, I guess just very quickly, I mean, there's the Marshall Inquiry, which really was a turning point for criminal justice in Nova Scotia, changed the way criminal prosecutions are handled, identified the racism that existed in the system at that time. This was the late 70s, early 80s. The inquiry report came out in 89. But not only was the impetus of that, but he was then also fined for fishing eels in Pomkit Harbour, and led to Supreme Court of Canada decisions that sort of re-established or sort of redefined the Aboriginal fishing rights in Canada. So that was a major impact there, which really hasn't been fully realized yet, but there's work taking place on that. And then he was also involved in one of the first serious sentencing circles, and so was sort of a trailblazer when it comes to restorative justice sort of principles being adopted into courts in Nova Scotia and thus in Canada. So really interesting. I'd recommend Jane McMillan's book. Jane McMillan was Donald Marshall Jr.'s partner for a time. Actually was fishing with him that day in Pomkit, and they were just trying to get by at the time. She's a really good author, very well written. Truth and Conviction is the name of the book, so I'd highly recommend that to people that are interested. And keep an eye out over the coming weeks and months for these videos that are emerging from Friends United as well. Quite a fascinating project, really interesting discussions. All right, so that's an introduction. Today I'm going to be covering, as I do, I try to cover in these videos stories that have been in the news across the country, sometimes focused on Nova Scotia, but things with a national impact as well. And this week I'm going to talk about 5 things. One is the Onslow Belmont report, which is from the Mass Casualty Commission. The Mass Casualty Commission is just releasing more and more documents, even though the hearings wrapped up a couple months ago now. And so that's been an ongoing situation, and that was in the news this week. Second thing is going to be the Court of Appeal in Nova Scotia wrote to the Bar Society about some adjournments, so I'll talk about that issue that they're having with the Court of Appeal. The third thing is a doctor from Amherst who has been charged with sexual assault has had his charges stayed, with some very serious allegations against one of the prosecutors involved in those cases. So we're going to talk about that. Nova Scotia Power. We've had some power outages lately in Nova Scotia, and I saw Nicole Nizdowski was tweeting about this and got a lot of response. So I just wanted to pick up on some of the things she was talking about on Twitter with Nova Scotia Power, the Nova Scotia Power Privatization Act from the early 90s. And then finally, I'm going to talk about the this week in the Emergencies Act inquiry. We've been hearing lots of factual things over the last few weeks. This week, it got into some legal analysis with the Prime Minister's National Securities Advisor, Jody Thomas. So I'm going to come back and finish with the Emergencies Act inquiry. All right, so story number 1, the Onslow Belmont report. And what came up was a memo from an internal RCMP report, which is the Hazardous Occurrence Investigation Team, HOIT, and this memo was from January of 2021. So a long time ago, before the evidence started at the inquiry, yet we're just getting this disclosed now after all of the proceedings are done, so that's a problem in itself. The report, the memo was talking about the Onslow Belmont Fire Hall. And for those that don't recall, or just a quick refresher, what happened there was these 2 officers stopped well short of the fire hall. In their evidence, said that they thought they saw the killer, Gabriel Wortman, standing in front of the fire hall next to an RCMP vehicle. They opened fire on the fire hall. Fortunately, they missed. The shots missed by wide margin in some cases, not so wide in others, but missed. So nobody was physically injured, but there's been great impacts from that. People inside were traumatized as a result of it. And the there was a report from the Serious Incident Response Team, the Nova Scotia entity that investigates any time that an RCMP officer is involved in potential criminal activity or shootings. And so SiRT did a report here, cleared the two officers, Terry Brown and Dave Melanson, of any liability, and criminal liability in that case. And this hazardous occurrence investigation team memo is critical of the SiRT conclusions, and many others have been, including myself, have been critical of the SiRT conclusions there. I mean, SiRT cleared the officers of any wrongdoing. It seems clear to me that they were way too far back. There's disputes over, they said they yelled out a warning or they tried to give a warning. Nobody else agrees with that. And so there are a number of issues with what they did there, and just the fact that they took those shots without really having a clear understanding of what was happening. So SiRT had used a consultant from British Columbia, this Joel Johnston, and the Hoyt report, the RCMP internal report, said that this Johnston report itself was inaccurate. There was lots of inaccuracies involved there. And actually, Justice Cacchione, head of SiRT himself at the time, had some concerns with Joel Johnston, hasn't used him as a consultant since then, yet ended up clearing the officers in that case. So this is just a memo. It's not the final Hoyt report, but that report is underway. It's not yet finished. We heard lots through the Mass Casualty Commission proceedings that there were these internal RCMP, investigatory processes taking place, but none of the reports have been prepared. This one has not been prepared. Chris Marshall from the RCMP, when asked by the media this week, said that the RCMP may share the report. I take it to mean that they will not share that report unless they are court-ordered or similar to do so. But we'll see. And if they do, I suspect that'll be critical of the two officers involved. The other thing is, of course, the Mass Casualty Commission, when they release their report at the end of March, will be no doubt examining this situation and likely also to criticize the officers. But we'll see. I mean, we have no idea what the Mass Casualty Commission is going to conclude about anything. But if they took a fair reading of the evidence, I think they'll be critical not only of the officers, but also of the SiRT report, which cleared them. So we'll see. And if anything serious comes out of the Mass Casualty Commission report or the Hoyt report, I wouldn't be surprised if some disciplinary action was taken against those officers. So we'll stay tuned on that one. Okay. And as I said, more to come later in the week on the Mass Casualty Commission closing written submissions. Okay, second story, out of the Court of Appeal. This was reported Tuesday in All Nova Scotia. The Court of Appeal, in a very unusual move, wrote to the Nova Scotia Barristers Society saying there have been too many adjournments in September and October, and that it was having a serious effect on the court, and that it raised some ethical issues within the legal profession, which it does. So there were 12 appeals adjourned in September and October, which represented a third of the cases before the Court of Appeal. The Court of Appeal, of course, hears criminal cases, family law cases, civil law cases, all sorts of things. Now, in criminal cases, of course, delay, well, in civil cases too, but in criminal cases more so, delay has been identified by the Supreme Court of Canada as a serious issue, and this Jordan case before the Supreme Court of Canada set hard deadlines in different levels of court. That doesn't apply to appeals. That's not the issue. It's not the delay that's the problem with these adjournments. It's that it's annoying for the judges. I guess it's more than that. I mean, so appeals, in a sense, if you've ever been to the Court of Appeal and watched one, they may seem like they're fairly brief affairs. I mean, you go in as a lawyer, and I've been to the Court of Appeal lots of times. I enjoy doing appeals. You go in and you give a presentation, which might be 20 minutes long, might be a half an hour. It's not going to be too long, typically. Supreme Court of Canada, it's even shorter, actually, in many cases. So, and then you have a 40-page factum. So, in a sense, it's very brief, but there's a lot of work for the judges. The judges, so when you file an appeal, you have to do so within 30 days typically, and then you have to order a transcript of the trial, and you have to provide the transcript and all of the evidence that was in the trial to the Court of Appeal. So the judges need to review everything that happened at the trial. They need to read through the transcript. They need to review the evidence. They need to review the factums from both parties and, start thinking things over before they get to the actual Court of Appeal hearing itself. So there's a great deal of work that happens in the months leading up to an appeal, and so when it gets adjourned, in the weeks or days ahead of an appeal, all of that time that was used by the judges to prepare for that, well, it's wasted in a sense. It's like studying for an exam. Yes, you do the work throughout, but you then prepare heavily close to the end towards the time you're writing the exam. And so that intense preparation, you can't just replicate that if you have you have to replicate that if the appeal is then heard, 3 or 4 months' time. You can't just rely on something you thought about or you read, months ago. You're going to have to do it again. So it's a real waste of time for the Court of Appeal, and it's precious time. And so it's, anyway, extraordinary. Now, there was an indication in the All Nova Scotia article that the issue was transcription services in Nova Scotia. And I know that there's only so many people transcribing trials, but typically, so when you get an appeal, one of the first things you do is you have to supply a certificate of readiness as the lawyer. So what that means is you have to be able to certify that not only have you have a copy of the order and of the decision, but you've ordered the transcript and have been told by the transcription service roughly when the transcription will be ready. And so if the transcription of the trial is going to be ready in May, well, they're not going to schedule the appeal in May or June. They'll schedule it in the months later. So doesn't really hold up to me that the transcription would be the reason here, but perhaps. Anyway, there is an ethical responsibility lawyers have to navigate cases in a timely and efficient manner. So nobody's been disciplined for that, but that letter, if things continue, wouldn't be surprised if individual lawyers perhaps, or if cases get dismissed if they're not ready to go. So that was an unusual thing. I thought it would be interesting to bring to people's attention. Okay, second story. That was the second story. Third story is this doctor out of Amherst, SiRT, and there's a decision released from Judge Bégin out of Truro Provincial Court. By the way, you can get these decisions on the Courts of Nova Scotia website, and really interesting decision. So what Judge Bégin has done at the request of the prosecution is he's stayed the charges, but what that means is they're on hold, and you can stay charges for up to a year. Sometimes done if the Crown's just not sure if they're going to pursue the charge, and they just want to, all right, we'll just put that on hold. There's no court date scheduled. It's just the charge is stayed and it's in limbo. The person is not acquitted. The charge can be brought back at any time. So in this case, yes, the Dr. SiRT has 3 charges of sexual assault from 2021, but the issue was the prosecutor for those charges, Mary Ellen Nurse, back in 2004 had represented a 4th woman who had a civil case alleging sexual assault against the same doctor. And at that time, Ms. Nurse had written to the RCMP saying, what are you doing about this sexual assault case? Do you have it in a file? Are you laying charges? Because, of course, if the RCMP was laying charges, that would give a lot of leverage for the civil claim. So she was interested in what's the RCMP doing. Okay, a couple of years later, Ms. Nurse becomes a Crown prosecutor and has been since. Well, now she's involved in the prosecution of sexual assault charges against this very same individual, and there's an allegation that she either pressured or guided the RCMP to then go back to 2004 and look at that other incident and lay charges based on that historical account. So, Dr. Fashtaranti's lawyer, Stan McDonald, out of Halifax, who, by the way, is definitely top 3 criminal defense lawyers in the province, if not better than that. Stan, he's great at this. He's been around for a while, and so whenever you see his name attached to a case, actually Judge Bégin, I would say the same thing. Whenever you see their names attached to a case, you can have confidence that they have something there. It's not just throwing something against the wall to see that it'll stick. So the question is, in this case, so what Stan McDonald is asking the court to order, had asked the court to order, was the correspondence between the Crown Office and the RCMP about these charges, to see if Miss Nurse had written the police to suggest charges or to discuss them. Well, the Crown said that correspondence is all covered by solicitor-client privilege and should not be disclosed. Well, so that was the application. Should those letters, any correspondence, emails back and forth, be disclosed to the defense? And Judge Bégin said, yes. This is extraordinary circumstances. Normally that wouldn't be disclosed. It would be solicitor-client privilege, litigation privilege. There's different reasons why that wouldn't be disclosed. But in this case, because it's so unusual, because the same lawyer was involved years ago and seems to be involved again in a similar situation, that there could be an abusive process there. So there's an abusive process application hearing scheduled for December 13th and 14th. And in the meantime, what the judge ordered is that the Crown needs to disclose all of that correspondence, not directly to the defense, but to the judge. The judge will review and see what can then be disclosed to the defense, so that the defense can use that information in the application to see whether there was indeed an abusive process. So, abuse of process, not abusive process. So that'll be something to watch. I wouldn't be surprised if the Crown just decides to withdraw all of the charges against Dr. Fashtaranti. Though if they're considered serious enough, and I don't know the details of the allegations, then they'll probably go through all of these steps and see what the judge orders and see if the abusive process application is successful. I suspect, just based on what Judge Bégin said in his reasons, that if there's correspondence to the effect of Mary Ellen Nurse saying to the RCMP, hey, you should charge this doctor based on this information that I know about from 2004, then all of those charges will be withdrawn by the court as a consequence of that abuse of process. Okay, so we'll keep an eye on that. We'll see what happens in mid-December on that one and follow up. Next story is just a brief comment on the Nova Scotia Power Privatization Act from 1992, when under the Cameron government the Nova Scotia Power was privatized to knock off a lot of debt, accumulated debt from the provincial balance sheet. Anyway, so in that act, Nicole Nasdowski, whose brother was tragically killed at a Nova Scotia Power site, and there's lots of issues there on liability about who was responsible, workplace incident, and sounds like protocols were simply not followed there, and his death could have been easily avoided had they been. So she was going through the Nova Scotia Power Privatization Act and pointed out some sections. The last one is the one I want to talk about, but I'll go through the ones she's pointed out. One is Section 15, subs 2 and 3, which is that Nova Scotia Power does not pay federal income tax. So they are charged federal income tax, but we, the taxpayers, pay it for them. All right, that's one. Section 18, sub 2 is that the Nova Scotia Power does not pay municipal taxes either, except for deed transfer taxes when they buy and sell land. Third one was Section 19, sub 3, that Nova Scotia Power can expropriate land. they have the same rights as the government does. If Nova Scotia Power needs a certain tract of land in order to, put power lines through or whatever they need to do, they have the power to expropriate land. Now, when you expropriate land, you are obligated to pay fair market value to the owner, but it's still an extraordinary power for a non-government entity to possess. All right, but the one I wanted to talk about for a second is Section 23, which is the limitation on liability. And it says, and I'm going to quote it, it says, in respect, so they have no liability in respect of any delay, interruption, or failure. So a partial or total failure of power. Okay, quote, where such damages are caused by something which is beyond the ability of the company to control by reasonable and practicable effort. All right, so what does that mean? Damages are caused by something which is beyond the ability of the company to control by reasonable and practicable effort. Well, you can't control the weather, but you can control how you build the system to withstand predictable weather. So, of course, you're going to have weather. So I say that what it should mean is weather that is predictable, that is sort of ordinary for Nova Scotia to withstand. The power system should be able to withstand predictable weather. And secondly, I would say that it should mean that Nova Scotia Power, their performance standards in terms of being, power outages and such, should be comparable to other coastal power providers, up and down the coast of the United States, east and west coast. See what other power companies are doing, what their performance is like, and compare that to Nova Scotia Power. If the gap is significant, I'd say Nova Scotia Power should have some liability, even under that limited wording. Now, of course, the other thing is, if that wording is too vague, or if it seems to be being interpreted in a loose way or a non-restrictive way by the UARB, then it's always open to the government to adjust that language to specify certain standards. So that's always something that can be done. And anyway, we'll see if there's any public pressure to do so. But I thought that was an interesting look at Nova Scotia Power's Privatization Act. All right, last thing. I'll cover this quickly, which is the Emergencies Act inquiry. Some really interesting week, and this was, I didn't watch everything sort of blow by blow this week because I was quite occupied with the Friends United stuff, but the National Security Advisor, Jody Thomas, Miss Jody Thomas, the Security Advisor to Prime Minister Trudeau, was testifying about what the legal standard is in this Emergency Act inquiry. So the whole question behind the inquiry was whether the Emergencies Act was necessary to invoke. And earlier, before Ms. Thomas testified, we heard from Brenda Lucki, the head of the RCMP, that the RCMP had a plan to address the protest without the Emergency Act powers. Now, we haven't seen that plan, and apparently the federal cabinet wasn't provided the plan either, but we're told it existed. Okay, that's one thing. Second is that we heard from the Canadian Security Intelligence Service, CSIS, that the protest did not amount to a national security threat, in quotes, in their opinion. Okay, so the lawyer for the convoy says, well, that should determine the whole thing. And the reason why they say that is the way the Emergencies Act and the CSIS Act interact, and I'll explain. Okay, in the Emergencies Act, a public order emergency is what the government needs to determine whether there is a public order emergency. Because if there is a public order emergency, then you can invoke the act. Okay, so what is a public order emergency? Well, it says a public order emergency is an emergency that arises from threats to the security of Canada and that is so serious as to be a national emergency. All right, well, what does that mean? So what is a threat to the security of Canada, the Emergencies Act says, well, look to the CSIS Act for that definition. So the CSIS Act says a threat to the security of Canada is something that there's four possibilities. One, that it involves espionage or sabotage. Secondly, that it is foreign influenced activities and they're clandestine or deceptive. Thirdly, that they threaten or use serious violence for political, religious, or ideological purposes. And fourth, that they're aimed at there's some actions aimed at the overthrow of the democratically elected government. Okay, but it specifically says that these do not include lawful protests, advocacy, or dissent. So that's the question in this case. Does it fit one of those four things? And I think they're looking more particularly at C, that it's a threat or use of serious violence for political or ideological objectives. But in other words, that go beyond a legitimate lawful protest. Well, I'm not sure that they're there, but that's all still contained within the CSIS definition. We heard from CSIS that they didn't think, it was their opinion that it didn't meet that definition. Now, just because it's their opinion, CSIS's internal opinion that it didn't meet that, doesn't mean that the government needs to share that opinion. But, of course, they're going to have to be very persuasive if they're trying to, in effect, overrule CSIS's own internal conclusions. But I think they're looking at another piece of this, which is, so when I said, what is a public order emergency? It's an emergency that arises from threats to the security of Canada. So arises from, so if it makes me wonder if the government is going to try to do this interpretation, which is, okay, yes, there was some threats, threats to use violence. There wasn't really much actual violence, so threats to use violence, and that those threats then sort of blossomed into or mushroomed beyond that into this other broader, maybe less threatening, but certainly disruptive event. So I think they're going to really lean on those two words, arises from threats to the security of Canada. So we'll see. I'm not sure if that's what Ms. Thomas was really getting at, or if so, it's a little bit of a stretch, but the words are there and they are there to be stretched, I guess, in that sense. So we'll see. But I don't think, I can see what she's saying. I don't find it persuasive myself, but Justice Rouleau may, and that's the opinion that counts. Well, and the people of Canada, their opinion counts as well. So we'll see if that's, if people find that persuasive. But there is something there. It's not just a matter of, well, if CSIS says so, that's the conclusion. The government can look a little bit beyond that opinion, and certainly they're motivated to do so if they're trying to justify the invocation of the Emergencies Act. Anyway, okay, so that's great. That's it for today, November 20th, 2022. Hope everybody enjoyed that content. Leave a comment, like and subscribe, share it with others, and keep an eye out on the YouTube channel for those other programs which I'm going to post this week. One being a review of the final submissions from the participants of the Mass Casualty Commission in Nova Scotia, and the other being Chapter 1, the Introduction to Deficits of Trust. So until then, thank you everybody for watching. Thank you for listening, and we'll see you next time.